morning, everybody. This is Chandra Andrade. I'm a partner in our employment practice here at Ferrella. I specialize in counseling management and employers about compliance with employment laws and policies, as well as defending employers in connection with employment-related lawsuits and administrative actions. Rebecca?
Yep. Good morning, everyone. I'm Rebecca Stevens. I'm a senior associate in Ferella's employment group, and similar to Chandra, my practice consists of representing and advising management and employers under federal and state employment laws. Thanks for joining us today.
Next slide. So we'll start with just a quick overview of our presentation today. So there's kind of two parts to it. The first part will be covering legislative and judicial changes, most of which came out in the last month, or at least took effect last month in January. We will cover some expanded coverage under CFRA, as well as updates to the DFDH mediation program, new laws around personnel records and notices, as well as minimum wage updates. And then we'll also discuss template employment document updates, which includes FEHA and labor code amendments and arbitration issues. And so then we'll turn to a segment on COVID-19 requirements and best practices, with some of these rules actually just coming out and changing in the last week or so.
So starting with employment document updates, this year we've continued to see some legislative changes that are still coming out of the Me Too movement, which has been going on for the last couple of years. And the big changes this year relate to confidentiality provisions in employment documents. So we'll get into those details over the next few minutes. And then we'll also be talking about some updates related to arbitration agreements. There's been some litigation around that, and then a new law that was recently passed by Congress that's expected to take effect sometime in the near future. Next slide. So just as a quick reminder of existing law, going back to 2019, there was a law passed that banned confidentiality provisions in settlement agreements that would have prevented the employee from disclosing factual information related to sexual assault, sexual harassment, workplace harassment or discrimination based on sex, and retaliation for reporting harassment or discrimination based on sex. So that was what the law was up until this year. Next slide. This year, Senate Bill 331 amended that statute to make it even more broad. And now, whereas the old law only prohibited confidentiality relating to sexual harassment and sex discrimination, there's now a much broader prohibition on confidentiality provisions in settlement agreements that would prevent the employee from disclosing factual information relating to any type of harassment or discrimination based on any protected characteristic. So race, national origin, disability, any protected characteristic under the law. And also confidentiality provisions can't prevent the employee from disclosing information about retaliation for having reported harassment or discrimination based on any protected characteristic under the law. Just a couple of caveats here. This applies to settlement agreements of any filed claim. So when an employee has filed a lawsuit, a charge with an administrative agency, an arbitration, anything like that, a settlement agreement of those claims, that's where these confidentiality provisions are no longer permissible. This statute does not pertain to a settlement, for example, of a demand letter that is issued before litigation where nothing's been filed. So this wouldn't apply in that context, only when the claim has actually been filed. Next slide. Similarly, a reminder of existing law going back to 2019. Back then, there was a statute passed that prohibited employers from, as a condition of employment, including for a raise, bonus, or continued employment, requiring employees to sign a document releasing their claims under the Fair Employment and Housing Act, any kind of agreement that would prevent them from disclosing information about unlawful acts in the workplace, or signing a statement that they don't possess any claim or injury against the employer. So this used to be a somewhat common practice when an employee would get a raise or a bonus or something along those lines. In connection with that payment, employers sometimes would ask the employee to sign a document saying, I'm acknowledging I don't have any claims, or I'm releasing claims under the Fair Employment and Housing Act. But as of 2019, that was no longer permissible. Next slide. And so similarly, Senate Bill 331 also amends this law from 2019 to now say that it also applies to separation agreements. And specifically, the language is any agreement related to an employee's separation from employment. So if you're offering an employee, let's say a severance agreement, a departing employee, you're asking them to sign a document releasing claims against the employer in exchange for some type of payment. Now you can't have in that agreement a non-disparagement provision that would prevent them from discussing unlawful acts in the workplace. And specifically, if there is going to be a non-disparagement provision in a separation agreement, there has to be this very specific carve out that says nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you believe is unlawful. So you'll note that this is pretty broad. It's not limited to just actual harassment or discrimination. It's any conduct that the employee believes is unlawful. So a pretty broad statement that now has to be included in these agreements. And again, I think the underlying goal here relates back to the Me Too movement, where there was a lot of complaining from employees and advocates for employees about these types of confidentiality provisions that would prevent them from later disclosing information about something that had happened in the workplace, like harassment, discrimination, retaliation, et cetera. Next slide. And then this new law also added a couple of additional requirements related to separation agreements. Separation agreements now have to also state that the employee has the right to consult an attorney and has to offer a reasonable time of at least 5 business days for the employee to consult with an attorney. It is permissible for the employee to sign the agreement before the 5 business days runs, but it has to be at the employee's election, and the employer cannot force them to do it, can't offer any kind of incentive for them to do it. It really has to be a voluntary decision on the part of the employee. The law is clear that you can still require the confidentiality of the payment amount in a separation agreement. So usually that's pretty important to employers wanting to make sure that how much they paid the employee remains confidential. That's still allowed. And the agreements can still protect trade secrets, proprietary information, or confidential information that does not involve unlawful acts in the workplace. It's another thing that's usually pretty important for employers in this context. Next slide. So just a couple of key takeaways from this section. Separation and settlement agreements can still require the confidentiality of the payment amount. That's allowed for both settlement agreements of claims and separation agreements where an employee is departing. Keep in mind, though, that there was a change a couple of years ago under federal law that prohibits tax deductions for sexual harassment settlement payments that are required to be kept confidential. So you'll have to kind of carefully navigate, probably on a case-by-case basis, where to put the confidentiality and thinking about the risks and benefits of each approach. And then obviously now there are severe limitations on the confidentiality of information relating to unlawful conduct. So in a settlement agreement of a filed claim, there can be no confidentiality of the facts underlying a claim of sexual assault or any type of harassment, discrimination, or retaliation. And then any other type of agreement that's in connection with a raise, a bonus, or the employee's separation from employment, or an agreement that would be as a condition of employment or continued employment, you cannot require the confidentiality of unlawful acts in the workplace, including things that the employee believes are unlawful. There is still an open question about the confidentiality of settlement agreements where the claim hasn't been filed. So if a demand letter, let's say, comes in and nothing's been filed with an agency or a court yet, it's just not clear whether you can have these broad confidentiality provisions in that context. We have had some plaintiffs' attorneys already arguing that a settlement agreement relating to a demand letter, if the demand letter alleges wrongful termination, would be an agreement related to the employee's separation from employment. And that would mean that you couldn't have that kind of confidentiality in there. Or similarly, there's a carve out in the statute that says you can have confidentiality if it's a claim that's resolved through the employer's internal dispute process. So it's kind of a gray area. The statutes are not clear on this point. I think there's likely to be possibly some litigation or maybe some amendments to the statutes coming out, but that's kind of the open question that we're all looking at coming out of these new amendments, and we'll just have to see how it develops. Next slide. A couple of updates about arbitration. You all may remember that AB 51, which was passed in 2019 and set to take effect in 2020, had banned mandatory arbitration in California as a condition of employment, continued employment, or the receipt of an employment-related benefit. Before that law could really take effect, the U.S. Chamber of Commerce challenged the law in federal court, claiming that it conflicted with the Federal Arbitration Act, which is a federal law that states a broad national public policy of enforcing private arbitration agreements. The U.S. District Court actually agreed with the U.S. Chamber of Commerce and issued an injunction that prevented AB 51 from taking effect, basically finding, well, this California law that seems to kind of prohibit mandatory arbitration is in conflict with this federal law, and in those cases, the federal law overrides and means that the state law can't take effect. So there was an injunction from January 2020, basically preventing this law from being enforced. However, in September of 2021, the Ninth Circuit reversed the federal district court and found that AB 51 actually does not conflict with federal law because it's focused on the formation of the agreement and specifically whether the arbitration agreement is voluntary. But if there is a voluntary agreement, it still allows for the enforcement of arbitration agreements. So the Ninth Circuit reasoned there's no conflict, the state law can take effect. Litigation is ongoing, expected to continue. The U.S. Chamber of Commerce has requested an en banc hearing by the Ninth Circuit. I think we all expect that this could be a case that goes all the way to the U.S. Supreme Court. But in the meantime, the decision that enjoins enforcement of AB 51 is still in effect. So AB 51 is not being enforced at this time. There are a few options while this is sort of remaining in flux. We've seen employers taking a variety of approaches. Some employers have decided that they're just going to stop using arbitration agreements just because they don't want to risk the risk of finding that their agreements are unenforceable. So we've seen some employers just kind of throw that out. We have seen some employers update their arbitration agreements to make them voluntary instead of mandatory. Under AB 51, if you were following that statute, that means that the arbitration agreement has to be a voluntary opt-in process. It can't be an opt-out process. So you'd have to have the agreement specifically say, this is voluntary. You can choose whether to sign or not. Obviously, that makes it complicated because you may have some employees that will not sign. You may have some employees that do, some that don't. It just could create complication. And then we have also had some employers who've decided, we think AB 51 is never going to take effect. We think the U.S. Supreme Court or the Ninth Circuit will just strike it down in its entirety. And those employers have decided to continue requiring mandatory arbitration. Of course, the risk there is that if AB 51 is not struck down, it could mean that any arbitration agreements entered after January 1st, 2020 are invalidated. It could also result in some civil penalties and fines for employers that continued to require mandatory arbitration after the law was passed. So we'll keep following that, but still in flux on that issue. Next slide. An update from just the last couple of weeks. You may have been following this as well, but U.S. Congress on February 10th passed a law banning the arbitration of sexual assault and sexual harassment claims by employees. President Biden is expected to sign the bill into law, but hasn't done so yet. But we do expect that the law will go into effect in the near future. And basically the effect of the law is that any existing arbitration agreement, even if it's already been signed, would not be effective as to sexual assault or sexual harassment claims, and employees could still choose to file those claims in court. So it would essentially provide a little carve out for those types of claims for employees to go to court. Obviously, some open questions here. What happens if an employee files a lawsuit alleging sexual harassment, but also like a race discrimination claim or a wage claim of some kind? It's not clear whether that entire case could be filed in court or whether only the sexual harassment claim could be filed in court, and then the rest would have to go into arbitration. So we'll just see how that all develops over the next, several months or years. Next slide. And then just a couple of quick updates on arbitration. You may recall that as of January 1st, 2020, there was a law passed requiring the drafter of an arbitration agreement to pay all required arbitration fees and costs within 30 days of the due date. If the employer, usually that would be the employer, if the employer fails to pay the fees on time, it means that they would waive their right to compel the employee to proceed in arbitration, and the claim could be moved back into court at the employee's election. And there could also be sanctions imposed as well. Next slide. So kind of consistent and following up on that law, SB 762, which took effect this year, now requires arbitration providers to immediately provide an invoice for the total arbitration fees once the requirements necessary to start the arbitration have been met. And then all parties have to agree to a payment extension before the provider can allow it. So, just more requirements put in place for employers. It's probably clear to you that the state of California is kind of trying to cut back on arbitration of employment disputes, and just another kind of hammer that they're dropping on this issue. Next slide.
So there's a slight tweak to the California Family Rights Act that took effect this year. As most of you are aware, the California Family Rights Act, or what we call CFRA, provides 12 work weeks of job-protected time off work if an employee needs that time to bond with a new child, attend to their own serious medical needs, or care for a close relative with a serious medical condition. And as of a legislative change from a couple of years ago, private employers with fewer than 5 employees are exempt, but otherwise, if you have 5 or more employees, you are required to comply with CFRA. So in 2020, a prior Senate bill had expanded the list of relatives whom employees can take time off to care for under CFRA, and there had been a slight confusion as to whether that expansion would extend to parent-in-law. And so what AB 1033 does is essentially just clarify that in fact they do. So parents-in-law do qualify as a family member for whom an employee can take time off work under CFRA. There were a couple of other changes that were actually not enacted in the legislative session. Essentially, those changes could have further expanded the list of people for whom CFRA benefits apply to include a designated individual, whether or not that person was a relative. So for example, a live-in boyfriend or girlfriend. And there was also a bill that would have increased the wage replacement rate for paid family leave benefits. So neither of those laws passed, but as we see in a lot of legislative sessions, these types of bills can be recycled over time and potentially passed in the future. So just be aware of those. Next slide. So on this, we just wanted to point out that there are some requirements around agricultural workers being provided personal protective equipment. This law doesn't create any affirmative obligations for employers. It's really just an FYI that we wanted to raise. Essentially, existing law already required the California Department of Public Health to establish a stockpile of PPE to supply to essential workers for 90 days. And what AB 73 did this year was expand the definition of essential workers to now include agricultural workers as well. And then health emergency now includes wildfire smoke events, which, as we know, has been taken hold in California over the last several years. So there'll be some new guidelines coming out for the procurement, management, and distribution of PPE to essential workers. But again, more just an FYI for those folks in the cannabis business that have agricultural workers in their workforce. Next slide. So in terms of the DFEH mediation program, as a little bit of background, existing law required the Department of Fair Employment and Housing to create a small employer family leave mediation program for alleged violations of family care and medical leave provisions. And this program was applicable to employers with between 5 and 19 employees, so a little bit smaller employers. Existing law authorized the employer or the employee to request that all parties participate in a mediation through the DFEH's Dispute Resolution Division after the department issued a right to sue notice on one of these family care and medical leave type provisions. An existing law had required the DFEH to initiate the mediation promptly after a request, and then also prohibited an employee from pursuing a civil action in court until the mediation was complete. So what AB 1033 does is just recast these provisions to require the DFEH, whenever an employee requests an immediate right to sue, alleging, again, a violation of family care and medical leave provisions, to notify the employee in writing of the requirement for mediation prior to filing a civil action if a mediation is requested by the employer. So essentially, this is just another bill that really hopes and aspires that employers and employees will choose to take advantage of this pilot mediation program to try to handle disputes that arise from family leave and medical issues, and try to kick those types of disputes between smaller employers and employees outside of the court system. Next slide. As most of you are aware, existing law requires that certain workplace rights and obligations be posted at the physical work site. What AB 657 did is effective in January. It allows, in any instance in which an employer is required to physically post this kind of information, it allows employers to also distribute the information to employees by email with the document or the documents attached. Note, this does not alter the employer's obligation to physically display the postings. So this isn't an excuse from the posting requirement. I think this law is just encouraging employers to disseminate workplace rights, notices, and obligations to its employees, many of whom are now working remotely. So, good idea to start distributing, especially to your remote workers, these workplace rights and poster notices electronically if possible. And then with AB 807, what that law does is just expanded the number of years for which employers have to retain copies of employees and applicants' personnel records. The previous time period had been 2 years, and this law expands the retention period to 4 years. Next slide. Minimum wages for workers with disabilities. So again, as a little bit of background, SB 639, which took effect in January, addresses a somewhat outdated federal policy back from the 1930s, which had allowed employers who secured a certain type of certificate to pay people with disabilities underneath the minimum wage. A number of employers in California that had previously been seeking these types of certificates, that number has been falling a lot over the years, especially since the 1930s. But what SB 639 does is just prohibits any new such licenses from being issued, and then also phases out the licenses that have been issued over the course of 3 years. So ultimately, the upshot is by January 1st, 2025, it will be illegal to pay any employee with disabilities less than the minimum wage, regardless of prior license status. Next slide. Just as a reminder that the California state minimum wage has increased effective January. So now employers with 25 or fewer employees have to pay a minimum of 14 an hour to its non-exempt employees. Employers with 26 or more employees have to pay 15 an hour. And perhaps an even more important caveat about these new changes in the minimum wage is that this affects the minimum salary that exempt employees have to earn in order to be classified as exempt. As you may probably know, the minimum salary threshold for exempt employees is twice the state minimum wage. And so now that the state minimum wage has increased, with that has increased the threshold salary requirement for exempt employees. I should note that salary is just one of multiple elements that need to be met if you're going to classify employees as exempt. So just in addition to the salary, you're going to also have to closely examine the duties. Make sure that they meet the minimum duties requirement as well for exemption. And it's always a good idea to seek legal counsel in any sort of classification decision. Next slide is just to remind you as well that many cities and counties have their own, oftentimes greater minimum wage requirements. So if you're in any of these cities, you need to be complying with these slightly greater minimum wage requirements for your non-exempt workers. Next slide. So AB 1003 also took effect last month, is a new law that underscores really the state's continued intense focus on the proper payment of wages by including significant criminal penalties for employers who commit so-called wage theft. And so at its core, AB 1003 adds a section to the California Penal Code, not just the Labor Code, which provides that the intentional theft of wages in an amount greater than $950 from any one employee or $2,350 in the aggregate from two or more employees by an employer in any 12-month period may be punished as grand theft, which is a felony. The statute defines wage theft to include pretty broadly any form of failure to pay wages or any type of compensation, including gratuities. And so for most employers, you're going to want to be looking at your policies and practices around the payment of wages, overtime, minimum wage, as we've talked about, and also any type of off-the-clock work and meal and rest break practices to make sure you're complying with wage requirements and avoiding potential criminal exposure under this new law. The other kind of key feature of AB 1003 is that for purposes of this new law, it specifically defines employee to include an independent contractor and employer to include the hiring entity of an independent contractor. And so if you have a workforce that includes independent contractors, you want to keep an eye out for them being paid properly as well, and definitely want to make sure that any classification decisions treating employees as independent contractors is correct. And because a lot of this law is also going at misclassification of employees. If an employer were to intentionally do that, I believe such would easily be considered a form of wage theft with many associated civil and now criminal penalties associated with that. So really, this law just turns up the volume on the punitive approach to wage and hour enforcement in California. As I sort of referenced, it's a good idea to maybe take another look at your policies and practices around wage payment and potentially even conduct an audit to make sure you're doing it correctly. Next slide.
Okay, now turning to the ever-evolving world of COVID-19 requirements and best practices, probably something that you're all dealing with day in and day out. We'll kind of cover some of the recent updates on that. So first, I think it's helpful to consider, which rules actually apply to your business, because as I'm sure you all know, there's, guidance and rules coming from all sorts of sources. Cal OSHA has enacted emergency temporary standards that are in effect for all employers with the following exceptions. So the only exceptions to those ETS are work locations where there's only one employee who does not have contact with other people, employees who are working from home, employees that are working from a location chosen by the employee that's not under the control of the employer. For example, if they're working from a friend's home, a relative's home, a library, something like that. And then employees who are covered by the aerosol transmissible diseases regulations, because those have their own rules and requirements. However, I think those would not apply to anyone on this call. Those are mostly workers in the medical industry or medical field. So the Cal OSHA ETS, if you don't fall within one of those exceptions, they do apply to you. In addition, employers have to follow the California Department of Public Health orders that come out. Sometimes those are in conflict with the Cal OSHA ETS, which makes it, even more confusing and difficult. The latest update to the Department of Public Health orders was from February 16th. So these are constantly evolving rules and requirements. And then just to add another layer, of course, you probably all know, each county sometimes has its own rules and requirements. So you have to keep an eye on those as well. Next slide. So one of the things that's required under Cal OSHA's emergency temporary standards is that all employers have a written COVID-19 prevention program that addresses all of the following. You have to communicate to employees about the employer's COVID-19 prevention procedures. The plan has to have specific procedures to identify, evaluate, and correct COVID-19 hazards in the workplace. The employer has to require and provide face coverings and respirators as specified in the emergency temporary standards. The plan has to also advise employees that they can wear masks at work regardless of their vaccination status, and that retaliation against employees who choose to wear masks in the workplace is illegal. The plan also has to address kind of complicated engineering questions like ventilation and administrative controls, as well as when personal protective equipment will be provided. The plan needs to also include a process for investigating and responding to COVID-19 cases in the workplace. Employers also, under the emergency temporary standards, have to provide COVID-19 training to all employees. The training pretty much has to cover all of the topics that are in the prevention program. Cal OSHA is planning to make online trainings that meet all these requirements available, but we've been checking and they're not available yet. So not super helpful right now when this requirement's already in place, but we expect that hopefully sometime in the near future, those will at least be available online. The employer COVID-19 prevention program also has to make testing available at no cost to employees who've had a close contact in the workplace. And if there's been multiple infections or an outbreak in the workplace, the employer has to make free testing available on a regular basis for employees who were in exposed work areas. The plan also needs to address how the employer is going to exclude from the workplace any COVID-19 cases and employees who've had close contact until they're no longer a risk. Of course, the plan needs to be consistent with the return to work criteria that's been established by the Department of Public Health. And then employers also have to maintain records of COVID-19 cases and report serious illnesses to the appropriate authorities. I will say that Cal OSHA has made a template COVID-19 prevention program available on its website, which is a good starting point for most employers. But you still, you'll see it. It's a pretty lengthy document. It requires a lot of detail, and it still requires a lot of thought and specific application to your particular workplace and the particular hazards that are there. So something that you really need to think about. We have been getting a lot of questions about, well, does this apply to all employers? What if I only have, X number of employees? As I mentioned, the only exceptions were the ones listed on the prior slide. So all other employers, regardless of size, do have to have this program. Next slide. There have been a couple of revisions to the emergency temporary standards in the last month or so. It used to be that a COVID-19 test being provided by an employer under those standards had to be a PCR test. The definitions have now been updated to include instructions that allow workers to use a self-test at home. However, it's not really that attractive of an option, I think, for most employers, because the requirement is that either a representative of the employer or a telehealth professional has to observe the use of the test. So probably have someone on Zoom or some other platform watching and instructing the employee on how to take the test and read the results. For most employers, I'm not sure that that's something you'd want to do. The definition of face covering has been updated to include more detail. And then the definition of fully vaccinated has been updated to now address the amount of time that workers have to wait between the first and second doses of a 2-dose vaccine. For testing, the big update here is that COVID-19 testing now has to be made available to even fully vaccinated employees after they've had a close contact in the workplace. So it used to be that the testing only had to be made available to unvaccinated employees, but now it's all employees regardless of vaccination status. And then during an outbreak, which is defined as 3 or more positive COVID cases in a 14-day period in the same site, the employer has to make COVID-19 testing available regardless of the employee's vaccination status on a weekly basis or twice per week during a major outbreak. And then lastly, on the topic of face coverings, there's now a new requirement that fully vaccinated employees as well as unvaccinated employees have to wear face coverings in transportation that's being provided by the employer. Next slide. So with respect to face coverings, under the Cal OSHA emergency temporary standards, employers have to provide employees who are not fully vaccinated with face coverings and ensure that they're properly worn over the nose and mouth when indoors and in vehicles. Outdoors, no employees need to use face coverings regardless of their vaccination status unless there's been an outbreak. And then employers also have to provide and ensure the use of face coverings by employees when required by the Department of Public Health, when an employee has had COVID-19 or had close contact with a COVID-19 case and returns to work, as explained in the CDPH's guidance, And then again, when riding an employer-provided motor vehicle transportation. Sometimes we've had questions from clients about whether employers need to ascertain the vaccination status of their employees. The standards do not require employers to know the vaccination status of employees. However, if you do not collect that information, you have to treat all employees as if they're unvaccinated, which means that they'd have to wear face coverings indoors at all times. So most employers are choosing to collect this information just because they don't want to have to go down that route, but it is up to the employer whether they want to do that. Next slide. The exceptions to the face covering requirement for employers is when an employee is alone in a room or a vehicle. Employees also don't have to wear face coverings when they're eating or drinking, as long as they're 6 feet apart or outside. Employees wearing respirators do not have to wear face coverings. And then employees who can't wear face coverings because of a medical or mental health condition or disability, because they're hearing impaired or communicating with someone who's hearing impaired, or when they're performing certain tasks that can't be performed while wearing a face covering. And then here, just to reiterate, employers have to provide face coverings to employees upon request, regardless of vaccination status. So if an employee asks for it, it has to be provided. Next slide. Now, the big change, as you probably all know from last week, is that the California Department of Public Health has decided to no longer require universal indoor face masking. It's only required in certain specified settings. So only unvaccinated persons now are required to mask in all indoor public settings and businesses. And then fully vaccinated employees are recommended to continue indoor masking when the risk may be high. Now, again, the caveat here is if you're not collecting information about vaccination status from your employees, then all employees still have to wear a face covering inside. But if you are collecting that information, then vaccinated employees no longer have to wear a face covering indoors. Now, you can choose to require it if you want to, but you're no longer required to by the state. And then at the bottom here is a list of places where masks are still required for everyone indoors, regardless of vaccination status. So public transit, schools and childcare settings, emergency shelters and cooling and heating centers, healthcare settings, state and local correctional facilities, detention centers, homeless shelters, and then long-term care facilities. Those are the places where masks are still required, regardless of vaccination status. Next slide. So on the vaccine front, some of you may have been following the federal developments on this issue. Under the federal OSHA, there was previously a rule that required any employer with 100 or more employees to require vaccination for all employees. That has been struck down by the US Supreme Court. So there is no longer any sort of federal or state requirement for employers to mandate vaccinations for employees. However, employers can choose to mandate vaccines for all employees as long as they meet the following requirements. So you can't discriminate against or harass employees or applicants on the basis of a protected characteristic. You have to provide reasonable accommodations related to disability or sincerely held religious beliefs. And you can't retaliate against anyone for engaging in protected activities, such as requesting a reasonable accommodation. So some employers have been seeing employees requesting accommodations to be exempt from the vaccination requirement, either because they have an underlying medical condition or disability, or a sincerely held religious belief that prevents them from getting the vaccination. Those are things that employers have to address. But you still can require vaccination as long as you're meeting those criteria. And again, employers can require employees and applicants to submit proof of vaccination, but those records have to be maintained confidentially. And you can ask employees and applicants to omit any medical information, such as diagnoses or anything else from those records before you receive them. Next slide. And then if there is a COVID-19 case in the workplace, the Cal OSHA temporary standards require employers to investigate and respond to those cases by doing kind of an investigation. So you have to determine when the COVID-19 case was last in the workplace, and if possible, the date of the testing and the onset of symptoms. You have to determine which employees may have been exposed to COVID-19 through a close contact. You have to provide written notification to all employees and independent contractors who are at that site at the same time as the person with COVID of their potential exposure. Keep in mind that the notice still has to maintain the confidentiality of the name of the person. So you would never kind of blast out the identifying information of the person who had the COVID-19 case. You would instead just say, you know, on this date, we think you may have been in close contact with someone who tested positive, but still maintaining the confidentiality of the individual that actually did test positive. Next slide. In addition, employers have to make COVID-19 testing available to potentially exposed employees who've had a close contact at no cost during working hours, with the exception of asymptomatic employees who recently recovered from COVID-19. Employers also have to exclude COVID-19 cases and employees who've had close contact from the workplace until they're no longer an infection risk, and then have to investigate the exposure and whether any work conditions could have contributed to the risk of exposure and if they should be corrected to reduce the risk going forward. And then for those who don't know, close contact is defined as being within 6 feet of someone with COVID-19 for a cumulative period of 15 minutes or more in any 24-hour period during the time that they're in the high-risk exposure period, which is usually a couple of days before the symptoms came on, and then 5 to 7 days after the onset of symptoms. Next slide.
Now we'll turn to isolation, quarantine requirements, and returning to work. This is also called exclusion requirements for employees. So the first slide here, we'll talk about isolation. And as a reminder, isolation applies if you are sick or test positive, even if you don't have symptoms. And then quarantine, which we'll cover next, applies if you are exposed to the virus without having a positive test. As a quick background on this, you may be confused because there has been different guidance coming out from different places, from the state, Cal OSHA, to the federal CDC, from the California Department of Public Health around quarantine and isolation requirements. Is it 5 days? Is it 10 days, et cetera? And fortunately, back in December of 2020, Governor Newsom issued an executive order, which basically just said that any quarantine and isolation periods guided by the Cal OSHA ETS are going to be overridden by any isolation or quarantine recommendation by the California Department of Health if those periods are shorter than those in the ETS. So kind of follow the path of least resistance, if you will, in terms of the periods. And fortunately, the California Department of Public Health has been pretty consistent about following the federal CDC guidance on this. So again, on this slide, we're looking at isolation requirements and returning to work for those who actually test positive. And here the requirements apply to all employees, regardless of vaccination status, previous infection, or lack of symptoms. And so everyone, regardless of vaccination status, can return to work after day 5 if symptoms are not present and they've tested negative. And then an additional 5 days apply if the person's symptomatic after day 5 and or if the employee is unable to or chooses not to test. And then there's some masking requirements that continue after an employee who had been isolating returns back to work. And then as a reminder for everybody, if you have a fever, the requirement is you stay home until your fever resolves, whether or not you've got a positive or a negative test. Next slide. So here we talk about quarantine requirements. So again, quarantine is where someone has not had a positive test. It's more when somebody's just been exposed to somebody else with COVID-19. And so these requirements apply to employees who are either unvaccinated or vaccinated and booster eligible, but haven't yet received their booster dose. And so for the unvaccinated and booster eligible, employees have to stay off work for at least 5 days after their close contact and then must test on day 5. And they can return if the test is negative and they're asymptomatic. If an employee is unable to or chooses not to test and does not have any symptoms, then the quarantine period can end and the employee can go back to work after day 10. And then there's, again, some residual masking requirements for folks who are returning after a quarantine period. If an employee has tested positive for COVID-19 at any point during their quarantine process, then sort of see the first slide around isolation. At that point, they have to follow isolation requirements having tested positive. Next slide. And so here this slide shows the requirements for employees who are up to date on their vaccination. So folks who are boosted or vaccinated and not yet booster eligible. So for these folks, you do not need to automatically quarantine after an exposure. And instead, you just have to test on day 5 and get a negative result after the exposure. There's also guidance around wearing a well-fitting mask around others for 10 days, especially in indoor settings. And then again, if somebody within this this quarantine framework ends up testing positive, whether they're vaccinated or not, you have to go back to the first slide on this series and follow the isolation recommendations that we talked about. Next slide. So exclusion pay, Cal-OSHA's emergency temporary standards require that employers maintain an employee's pay and benefits while an employee is excluded from the workplace because of a workplace COVID-19 exposure. So that's the key criteria here. If an employee has been exposed to COVID-19 at the workplace, then these exclusion pay requirements apply. If the exposure occurred elsewhere outside of work, then these requirements do not apply. That does raise the question of how are we supposed to know if an employee reports a positive test, did that employee get it at work or somewhere else? If an employer wants to challenge an employee's belief that they have been exposed to their COVID-19 at work, then the employer needs to investigate and essentially come up with some proof showing otherwise. There's a couple of elements of exclusion pay. Exclusion pay there's certain eligibility criteria for folks to take exclusion pay, which I won't go into too much detail, but of course has to be a COVID-19 related reason. So isolation, quarantine requirements like we talked about earlier. There's some ability to take exclusion pay in connection with vaccination and recovering from vaccination as well. A lot of employers wonder whether they can require employees who are excluded due to a workplace exposure to take paid sick leave. And the answer is that employers who have a paid leave policy that is separate and in addition to the paid sick leave that's required by California's paid sick leave law, may require their employees to use that separate sick leave as permitted by law. But the key is an employer cannot require an employee to use their standard paid sick leave allotment that's mandated by California law. So if you have a more generous sick leave policy, that can be applied to exclusion pay. If you're just giving employees the kind of standard, usually works out to about 3 days of the mandatory California paid sick leave, you cannot apply that to exclusion pay. Next slide. So COVID-19 supplemental paid sick leave, just as a little bit of background, in addition to exclusion pay requirements under Cal-OSHA ETS, the California legislature last year had passed a law requiring employers to provide supplemental paid sick leave from January 1st, 2021 through September 30th, 2021. That law only applied to employers with 26 or more employees. So that this slide and the new extension of COVID supplemental paid sick leave, which I'll touch on in a second, also only applies to these larger employers. So if you have 25 or fewer, you don't need to worry about supplemental paid sick leave. So unlike exclusion pay that's available under the emergency temporary standards, employees need not have been exposed to COVID-19 at work for supplemental paid sick leave to apply. They can have gotten COVID or had an exposure anywhere and still be eligible to take supplemental paid sick leave under this law. And so the key thing here is that last week, Governor Newsom approved a measure, I should say it's now been about 2 weeks, Governor Newsom has approved a measure reviving the statewide supplemental COVID-19 paid sick leave law, making it retroactive to January 1st, 2022, and in effect through September 30th. So any employee that reports having had to take time off as of January 1st, 2022, and going forward into September are going to be eligible for this supplemental paid sick leave. Note also that this is, as it's described, a supplemental benefit, and so employers cannot count their standard pre-COVID paid sick leave under California law towards the supplemental paid sick leave, similar to the exclusion pay framework I mentioned earlier. And also you can't apply the 2021 supplemental paid sick leave allotment towards the 2022 obligation. And then I should also note that unlike the 2021 supplemental paid sick leave law, this 2022 supplemental paid sick leave version cannot be applied to satisfy exclusion pay required by the ETS. Again, they're treated as separate and supplemental benefits to each other. And then finally, just as a reminder, neither the 2021 nor the 2022 supplemental paid sick leave law applies to employers with 25 or fewer employees, which I suspect is the case for some of the folks on this call. There's some other differences between the 2022 and the 2021 version. I will say that I won't go into detail there, but the main gist is the legislature has recognized that there had been quite a bit of sort of fraud in connection with employees trying to take advantage of these 80 hours of paid time off by falsely reporting that they had COVID-19 or falsely reporting vaccine-related side effects. So this law creates a couple of measures to try to prevent against that kind of fraud, if you will, in folks taking advantage of this type of sick leave. Next slide. Just as a quick reminder, I won't go into detail here either, but there are some local COVID-19 supplemental paid sick leave ordinances. So if you're in the city of Los Angeles, the county of Los Angeles, Long Beach, and Oakland, those are some areas that do have their own sick leave requirements, which are sometimes in addition to what we've covered on the state and federal side. Next slide.
Okay, so we've got just a couple minutes left, so we'll cover SB 606 quickly. The big takeaways are this is a bill that has really ramped up Cal OSHA's enforcement authority and ability to issue fines and citations for employers that violate OSHA standards. I think the pandemic helped get this bill passed, but it is not specifically related to COVID. It actually applies to any type of violation of Cal OSHA standards, beyond just pandemic related things. So, keep in mind that Cal OSHA's authority has now really expanded under this law. Next slide. So the first big thing that came out of Senate Bill 606 is that it's created this new category of violations that are called egregious violations. So Cal OSHA can issue citations finding that an employer has committed an egregious violation of Cal OSHA regulations if one or more of the following is true. This list here, basically if the employer made no effort to eliminate a violation, if there were, multiple fatalities, hospitalizations, a large number of injuries or illnesses, if there's a long history of prior violations, anything on this list, Cal OSHA can decide that the employer has committed an egregious violation, which comes with higher penalties, higher fines, et cetera. Keep in mind that each instance that an employee is exposed to one violation is considered a separate violation for purposes of issuing fines and penalties. So even if there's only one kind of instance of noncompliance, each time an employee is exposed to that one thing will be a separate violation. Next slide. And then there's this other category now of enterprise-wide violations. And there's now a rebuttable presumption that a health and safety violation by an employer with multiple sites is enterprise-wide if either the employer's written policy or procedure violates regulations itself, or if Cal OSHA has evidence of a pattern or practice of the same violation committed at multiple sites. So there's a rebuttable presumption there. So the employer would then have to provide evidence showing that this is not actually an enterprise-wide violation. If the employer can't make that rebuttal, then Cal OSHA can issue an enterprise-wide citation, which requires abatement, including heightened penalties up to a maximum of this very strange number of $124,709 per violation. Not sure how they came up with that, but that's clearly quite a stiff penalty, so something to be aware of. I will say there's a slight reprieve in that Cal OSHA cannot assess an enterprise-wide violation if the employer's policy was based on a regulation that only came into existence within the last 30 days. So I think there's some acknowledgement here, especially with COVID-19. Lots of things are changing quickly. Lots of rules are coming out. So if the rule came out within the last 30 days and the employer is in violation of it, then Cal OSHA can't find an enterprise-wide violation. The last kind of piece of SB 606 is that Cal OSHA now has the ability to do all sorts of enforcement actions, issuing subpoenas, getting injunctions, going to court. Those are new tools that have been added to Cal OSHA's arsenal by SB 606. So really just kind of an increased authority for Cal OSHA to investigate and remedy violations that it finds. So with that, that concludes our program. If anyone has any questions, we can stay on for a couple of minutes, but thank you so much for coming today, and we hope you got something out of our presentation.